By a letter dated 18 February 2025, the OSP graciously acceded to Mr. Ofori's request to return voluntarily to the jurisdiction between 14 and 30 May 2025, as the office deemed the indicated recovery period reasonable in the circumstances. Consequently, the OSP removed Mr. Ofori's name from the list of wanted persons pending his voluntary return to the jurisdiction based on his own indicated dates. Consequently, the OSP directed Mr. Ofori to attend the OSP in person on Monday, 2 June 2025 at 13:30 GMT for interview, which is today. The OSP emphasized that if he failed to voluntarily return to the jurisdiction within his stated dates, and if he failed to attend the OSP on the rescheduled date of Monday, 2 June 2025 at 13:30 GMT, his name will be re-entered on the list of wanted persons, and the OSP will consider him a fugitive from justice, whereupon the office will take all necessary legal steps to secure his return to the jurisdiction and attendance at the OSP at our own choosing. Then, by a letter dated 28 May 2025, Mr. Ofori's lawyers informed the special prosecutor that a medical expert has diagnosed Mr. Ofori with cancer and has earmarked 13 June 2025 for surgery, for which reason he would be unable to return to the jurisdiction as scheduled. His lawyer stated that to the knowledge of the OSP, this change in circumstances has been brought to the attention of the court, before which Mr. Ofori is presently pursuing a human rights claim against the OSP and the special prosecutor. His lawyer stated further that in order not to hold the office back in the performance of his function, they had Mr. Ofori's instructions of his readiness to go through video recorded interview for the purpose of eliciting his caution statement. His lawyers offered to meet the special prosecutor in person or approach the bench for the purpose of viewing Mr. Ofori's biopsy report, whichever suited the special prosecutor. Now, ladies and gentlemen of the media, this is where we are now. And let us step back a bit from the 28 May 2025 letter from Mr. Ofori's lawyers and place the matters in their proper context. I have intentionally went through a tedious timeline. The letter from Mr. Ofori's lawyers, dated 18 February 2025, clearly indicated that the possible surgical intervention to be performed on him was to occur on 20 and 21 March 2025, upon which reckoning the OSP carefully considered the recovery period and indulgently pushed Mr. Ofori's attendance at the OSP to 2 June 2025. Therefore, Mr. Ofori had a duty to promptly inform the OSP of any fundamental change in his medical circumstances on 21 March 2025, when the advertised surgical intervention was not performed, to enable the OSP reschedule a new date of his attendance at the OSP to accommodate any such material changes in his medical condition and treatment itinerary. Mr. Ofori has known, at least since 21 March 2025, that no surgical procedure was to be performed on him in March. Yet, he purposely sat by indolently and chose not to inform the OSP of such fundamental changes in his circumstances. Instead, about 67 days after learning of the alleged changed circumstances around 21 March 2025, Mr. Ofori elected to spring a surprise on the OSP on 28 May 2025, just 6 days before his scheduled attendance at the OSP, by offering to undergo a video recorded interview and a viewing of his biopsy report. Now, back to the 28 May 2025 letter from the lawyers of Mr. Ofori. As I said, this is where we are. By a letter dated 30 May 2025, the OSP declined Mr. Oforiatta's offer of video recorded interview for the purpose of eliciting his caution statement. This office has always insisted on his personal attendance, and we have indicated clearly to him that we are unwilling to waive it. If we were amenable to taking any such statement from Mr. Oforiatta in absentia, we would have done so in February and not waited to 2 June 2025. We want him here physically, and we insist on it. A suspect in a criminal investigation does not pick and choose how the investigative authority should conduct its investigations and the method suitable to him and his convenience. We will not countenance such conduct, not in this case or in any other case. Further, the OSP has declined Mr. Oforiatta's invitation to view his biopsy report as we consider it a pointless exercise. This is because it is common learning that the biopsy report contains nothing more than a conclusion upon the removal and examination of tissue, cells, or fluids from a living body that some disease or malady was indicated in the samples taken. A biopsy report is not an expression of a reasoned medical opinion that the subject of the report is an invalid and unable to travel, as Mr. Oforiatta seeks to suggest is his condition, and for which reason he says he cannot return to the jurisdiction. This much is clear. Since 24 January 2025 till date, Mr. Oforiatta has failed to show any medical report. I underline, he has failed to show any medical report which suggests that he is a travel risk and unable to return to the jurisdiction by reason of his medical condition. It has all been his say-so, his singular say-so. Therefore, the OSP views Mr. Oforiatta's lawyer's letter dated 28 May 2025 as an expression of utter bad faith on the part of Mr. Oforiatta, and it confirms our long-held, well-considered opinion and conclusion that Mr. Oforiatta has no intention of voluntarily returning to the jurisdiction and to attend the OSP. Further, this office is unaware of his purported information to the court, whether orally or by file processes, of the alleged change in his circumstances. Today is Monday, 2 June 2025. It is more than 3 hours past the scheduled time of Mr. Oforiatta's attendance at the OSP, and Mr. Oforiatta failed to attend the OSP today. Mr. Oforiatta's conduct is totally unacceptable and a baleful spite at law enforcement and criminal investigations. It ends here. It ends today. We will no longer accommodate him. Consequently, the OSP redeclares that Mr. Oforiatta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Oforiatta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Oforiatta, pending extradition or his surrender. Around the same time, I dispatched a request for extradition processes to be instituted for the provisional apprehension in any jurisdiction, extradition to the Republic of Ghana. The OSP will prefer criminal charges in the courts against Mr. Oforiatta in due course, whether in absentia or otherwise. The principle upon which we proceed is that no person, regardless of title, regardless of status, regardless of medical,
you can't do this to me, Mr. Speaker. Mr. Speaker, you are a leader. And you should know that when something is public record, especially in this house, we do not tender any evidence. Professor Mike Okwe, then Speaker, made a ruling on the matter in this chamber. You were seated here. Professor Mike Okwe wrote to the CID in respect of this matter. And so what other evidence do you want me to tender when it's captured in the Hansard? Anything captured in the Hansard, you don't tender any evidence. Mr. Speaker, I am saying that on that fateful day, Mr. Speaker, on that fateful day, when my house was raided by AK-47 wielding national security operatives, when they banged on my door, creating fear and panic, sending my 6-year-old child into a state of hysteria, into a state of fear. We had members here. They never commented on it. And I commend Professor Michael Kwe on that day when he stood up and ruled that what they were doing was wrong. Mr. Speaker, they took my phone, they took my laptops, and took it to the United Kingdom to investigate me. Today, a very simple matter. You are scared of it. Mr. Speaker, let me explain something. The OSC has declared Mr. Ken Ofori as a fugitive. As a fugitive. Mr. Speaker, in our local language, fugitive, in our local language, it means that or to put it simply, wajibam, or in the Hausa language, otilo, or to put it in a more simpler way, yagudu. It's as simple as that, Mr. Speaker. But Mr. Speaker, we should not be afraid of accountability. As public officials, when they took my laptop, it got to a point they couldn't even open the iPhone. I told them I was willing to come and use my fingerprint. It was then and there that they told me that the phones had been taken to the United Kingdom. I had to give them the password. Eventually, the very America that I was accused of, a minister was dismissed because it came here padded by almost $800 million. Mr. Speaker, on this auspicious day, on this day of reckoning, on this day of accountability, the only thing I can say is that we wish the man in white, 5 minutes. The best of luck.
Is up.
But Mr.
5 minutes is up.
The finance minister should come here and settle the scores as far as
5 minutes is up.
Thank you very much, Right Honorable Speaker.